According to the Eviction Lab, only 4% of tenants facing the threat of eviction have an attorney. That's compared to 83% of landlords. This means most tenants must navigate complex housing laws on their own, making it much more likely that they will lose their homes and risk harm to their employment, education, mental health, and well-being. Historically, the right to an attorney applied only in criminal cases. Civil matters like evictions were excluded. However, in the early 2000s, advocates began calling for a civil right to counsel in cases involving basic human needs, like the right to remain housed. Those efforts led New York City in 2017 to become the first in the nation to guarantee attorneys for low-income tenants who are facing eviction. The effects were impressive. Evictions fell sharply, and tenants with representation overwhelmingly remained in their house or had other positive outcomes. Inspired by these results, cities across the country began adopting their own right to counsel laws. In Detroit, where eviction filings have long been among the highest in the nation, the city passed its right to counsel law in 2022. And even though it's not yet fully funded, the impact for tenants is meaningful. According to the City of Detroit's 2024 Right to Counsel report, for tenants who are represented, more than 46% stayed in their homes. When tenants moved out, 94% received extra time to find other housing, and less than 1% were evicted. Today on Legally Speaking, we'll talk with the head of Detroit's Office of Eviction Defense, as well as an attorney and a tenant who will share firsthand how having legal representation during an eviction can change the course of a case and have a lasting impact on the tenant's life. We'll be right back. I'm Ashley Lowe, Chief Executive Officer of Lakeshore Legal Aid. We're a nonprofit law firm that provides free civil legal services to people living with low income, older adults, and survivors of domestic violence and sexual assault throughout the state of Michigan. Today on Legally Speaking, we'll be talking about Detroit's right to counsel law and how it's helping tenants who are facing eviction. Our first guest is Diamond Conley. Diamond is the director of Detroit's Office of Eviction Defense. She is a lifelong Detroiter, a proud Cass Tech High School graduate, and a former Lakeshore Legal Aid staff attorney. So she comes at this work with a wide variety of experience, and so we're so glad to have you here, Diamond, to talk about these things.
Thanks, Ashley. I appreciate you for allowing me the opportunity to be here and to see you again. I started my career at Lakeshore Legal Aid, and so forever grateful for that time there and kind of honored to be in this position and to be here with you today. So thank you.
Well, great. Let's talk about what's going on in Detroit's landlord-tenant court.
Okay.
And I want to talk about the law, but I also want to talk about what was happening before that. Before we had the right to counsel law,
Yeah.
What did it look like for a tenant? Did they have resources?
It was pretty tough, Ashley. So prior to right to counsel, we had 30,000 evictions being filed in the city of Detroit. And so that was tough because you had only 4% of those tenants being fully represented or able to afford an attorney. Mm-hmm. And we had over 80% of landlords who were able to, get an attorney in court and advocate for them. And so there's this imbalance of justice that we saw flowing through 36th District Court prior to right to counsel. And really just thinking about how difficult that could be for tenants. 36th is an interesting place. There's a lot going on, and tenants really had to try to navigate that space on their own. And usually they only had one opportunity, right? One hearing to navigate that space, to know what their defenses are, to get it out quickly enough for the judge to hear them. And if not, they could be leaving there with the judgment. And so, it was pretty challenging for our tenants prior to right to counsel, I would say.
Yeah, and that court was so busy that 30,000 eviction filings really is an outlier, has been an outlier in the rest of the country. So glad to see that things are going differently. So let's talk about the law. What's the main thing that it provides? What's kind of the big picture?
So our right to counsel ordinance in the city of Detroit enacted in 2022, but really we launched, the city of Detroit right to counsel launched in March 2023. The goal of that is to make sure that our tenants, they receive free legal representation. They have a right to free legal representation. And I want to really enforce that because there are I think still a number of people who don't have enough exposure to their right to the right to counsel. And so another reason why I'm grateful to be here, just so that tenants know when they walk into 36th District Court, they're facing a landlord tenant matter or an eviction matter, there is free legal help. There's free legal representation that they're entitled to.
So what kinds of cases are covered under the ordinance? Is it just eviction cases?
It's not just eviction cases. We primarily see eviction. I think over 60% of our cases are non-payment of rent cases. We have about 30% that are termination of tenancy cases. But then we do see a segment of land contract cases that come through, mortgage foreclosure cases, tax foreclosure cases. We take those as well. And a small segment of health hazard. And I want to say small, right? Because sometimes there's this perception that tenants come and they tear up properties and they're doing all of these things. But that's a very small portion of the cases that we take for right to counsel, and that we honestly see. It's primarily our non-payment of rent, termination of tenancy that we handle.
Okay, and then who's eligible? What makes a tenant eligible for services?
Yes, great question. Because even though there is this right, we do have some minor requirements. And so to qualify for the Right to Counsel program, you do have to be a Detroit resident, and your income has to be at or below 200% of the poverty level. And I don't think most people walk around knowing if they're at that level. And so there are attorneys and legal assistants available in court that can help a tenant assess if they qualify. I will say that most of the tenants that we see at 36th District Court dealing with the landlord-tenant matter do qualify for our services.
Right, right. And so you're the director of the Office of Eviction Defense.
Yes.
Talk about what the role of that office is.
Yeah, so I'd like to think that I play an important background role, right? Because I don't want to take away from our attorneys who are in court day in and day out, really representing tenants on a regular basis. And so what the Office of Eviction Defense does to me is we sort of provide the coordination and structure and funding to make sure that our attorneys are in court on a day in and day out basis, representing tenants. And so I provide the coordination piece between, we now have 5 legal service agencies in 36th District Court every day, or rotating on a daily basis, to provide that counsel that tenants deserve. And so I kind of make sure that is happening. A lot of what I do is, like I said, making sure the funding is available, making sure that I follow the requirements of the ordinance, right? We have important, outcomes that we should be trying to reach, and a certain population that we should be trying to make sure is receiving services. So that's a part of what the Office of Eviction Defense does. And then I come to spaces like this to really promote right to counsel and to talk about the importance of continuing to fund this law that our residents need in the city of Detroit.
Yeah, that's so important to make sure that this can continue into the future.
Yes. Yep.
Yeah. So tell me about the impact. What are we seeing, and what types? You mentioned that most of the cases are non-payment of rent cases.
Yes.
What about the tenants that we're representing? I know we collect a lot of data in that sense. So what do those tenants look like, and who are they?
Yeah, so I guess I will start with the fact that one of the outcomes I'm proud of is that we're starting to see a decrease, actually, in the number of cases that are filed in the city of Detroit. And so we have moved from that 30,000 prior to right to counsel into 20,000 eviction cases filed. And that's still quite a bit, but I'd like to think that we've seen that 10,000 case decrease because right to counsel is there and sort of pushing back on all of these eviction filings. And I'm hopeful that for 2025 will be a little bit less than the 20,000. And so we're continuing to see that decline in the number of eviction filings. And then what does the population look like? Yeah. That was your question. And so we see primarily African American women as the ones who are really relying on the right to counsel program the most, and over half of those women have children in their household as well. And so that is a really important population that is relying on right to counsel. We also see that, it was surprising to me, but about 35% of the cases that we take are people between 30 and 39. And so there's this population that is really, I think, trying to balance, all of the pressure of like maybe raising their family and trying to work and keep their housing, right? We see all the things in that era. I think that that's the reason why we see that. And then more surprisingly to me, over 90% of the people that we represent only make $40,000 or less. And so again, we kind of see that balance of trying to make sure you have housing, but also all the other challenges, financial challenges that life brings.
Right, and making $40,000 when you might have 2 or 3 kids and as a single parent,
it's tough.
That's going to be tough to make ends meet.
Absolutely, yeah.
Yeah. So I know we've talked about the types of cases and the outcomes, right?
Yes.
Like the reduction in the number of filings, which is huge.
Yes.
What other kinds of outcomes are you seeing?
So because we know finances is a tough situation for many of our clients, we try to make sure that we advocate for reduced fees. So if our attorneys are in court on a regular basis looking at ledgers to make sure that the amount that they say the tenant owes is owed, and we advocate in that space to reduce fees. We try to waive excessive late fees, waive excessive court fees, and so those are the type of things that we're advocating for. We're advocating for repair issues in homes, when tenants are living in substandard housing, because in the city of Detroit, there is a problem with properties being registered and landlords having the certificate of compliance. That's still something that we're fighting against. And so our attorneys are advocating in that space for, our tenants, our residents in the city of Detroit. But also, I'm proud to say that since we launched in March of 2023 and through August of this year, we have represented over 13,000 families in the city of Detroit, provided them with full legal representation, and we've been able to keep about 53% of those tenants in their homes. And so, that is a number that we're proud of. We want to see that increase, but that's pretty exciting for me. And then for the tenants that do have to move, because sometimes they have to,
Right.
we make sure most of those tenants, 97% of those tenants actually receive at least 30 days or more to move. And the statutory limit is only 10 days, right? So we advocate beyond that. And really the goal is for tenants that need to move, we want to make this an orderly relocation process. We don't want to see bailiff evictions. We don't want to see the stress of the trauma of having someone's belongings put on the street and them, rapidly having to leave their home. If they have to leave, let's make this a process that is as respectful to the tenant as possible.
Right. So even if someone's not staying in the home they're in,
Yes.
they have a dignified way to move to a new place and maybe time to find someplace that's appropriate.
Absolutely. That's the goal.
Yeah. So if someone wants to find out how they access services, what's the most important thing that they should do?
Please come to court.
So if you get served with a notice, go to court.
Yes,
Yeah.
because that notice will tell you when your first hearing is, and it's virtual. I think I mentioned this earlier. It used to be just a one hearing process for the most part, but now we've moved to a process where there's 2 hearings. And the first hearing is virtual, and so we really need tenants to show up to that hearing. That's the opportunity for you to complete the right to counsel intake, to possibly talk to an attorney about your case for the first time, and to get prepared for that second hearing that will be in person. But we absolutely need people to show up to court. And even if you don't make the first hearing, which we want you to, show up in person to the second hearing at 36th District Court. You can find our attorneys in room 417 in 36th District Court. And so I cannot stress enough the importance of showing up at this point.
Great, thanks. And Diamond will share with folks the QR code so that they can see the link to our informational materials that are on the website.
Okay.
And there's a ton of information there. So I just want to thank you for being with us today. This is information that's so important to get out to people who are facing eviction, and the work that you're doing is really amazing. So thanks for being here.
No, thank you for having me, Ashley. It's been great.
Thanks. Welcome back to Legally Speaking. Our next two guests have real-life experience with the right to counsel law in Detroit. We're going to start with Blythe Collins. Blythe is a staff attorney in Lakeshore's eviction prevention team, and every day she is representing tenants in eviction court. So, Blythe, thanks so much for being here today.
Thanks so much for having me.
Thanks. And our other guest is Janae Bradford. Janae is a former client of Lakeshore Legal Aid. She's a native Detroiter, she's a small business owner, and a live performance artist. And Janae, I just want to thank you for being here today and also for your willingness to share your story with us.
No problem. Thank you for inviting me.
It's great to have you. So Blythe, let's talk about what right to counsel looks like on a day-to-day basis. You're in court every day. What's it look like for tenants?
So for tenants, I think it can feel fairly overwhelming to walk into the 36th District Court. So it's frequently pretty busy. What you're going to do is you come in, you're going to go to the courtroom where your judge, the judge that you've been assigned to, is operating. You check in with the bailiff there, and what they're going to have you do is come speak to a right to counsel attorney. So you'll come into our clinic, which is in room 417. If you have not shown up to your prior online court date, at that point you'll go through the intake process with us.
Let's talk about that first hearing, the online hearing. So that's really, I asked the wrong question. I should have asked what's the first thing that the tenant experiences, because they get a notice, and then what do they do with that?
Yes, and I want to say the first thing the tenant should experience is the notice. So you should get some kind of notice from your landlord that lets you know what you have to do and how many days you have to do it. So usually pay your rent or leave your property, usually 7 days or 30 days, depending on your case. Then your landlord has the right to go and file an eviction case. You'll get notice that you need to appear at a Zoom hearing. It's very important that you log into that Zoom hearing. That's where you meet a right to counsel attorney for the first time.
Okay, so and when they come to court on Zoom, do they meet a lawyer?
So they'll first usually meet a legal assistant who will go through an intake process with them. Once we're sure that you're qualified for our services, then you'll be able to speak to an attorney who will give you legal advice regarding your specific case. So that advice is tailored to you and your goals.
Okay. And then what happens after that first hearing? Is that the end?
No, unfortunately, it's not the end. So at that hearing, you'll then get your next court date. That's the date that you need to appear in person. So you'll get, a special date to come play at the 36th District Court. So you'll come in, you'll come up to usually our offices on the 4th floor, and you'll meet with someone, the attorney usually that you spoke to at your first hearing. And at that point, that's usually where they decide if they are able to take your case for full representation and work with you moving forward throughout the rest of your case.
So you say full representation. Are there cases where maybe our attorneys aren't able to represent somebody in court?
Yes, sometimes, unfortunately, the staff, the volume of cases that get filed, we aren't able to represent every tenant. Okay. So we're able to advise any tenant who qualifies for services. Okay. Sometimes there are cases where tenants are okay to proceed on their own. We'll advise them how to do that best. Sometimes there are cases that we simply don't have the resources to move forward with full representation. But oftentimes we are able to work with the tenant to get the resolution that they are hoping for.
Got it. And then what types of cases are you seeing? What do the typical facts look like?
So the vast majority of cases that we see are non-payment of rent cases. So a tenant has fallen behind on rent for some reason. They are now in court because they haven't been able to catch up fully on their rent. And usually there's also some kind of a repair issue going on. It's very rare that I ask a tenant, do you have any repair issues? And they say no. When that happens, I kind of jump for joy a little bit. But usually there is some kind of a repair issue happening. So then we're kind of able to work with both problems at once. So we're able to work with that tenant to both put their landlord on notice about the repair issues and also work with them to try to come up with a plan to catch up on their rent.
Got it. Great. So Blythe, thanks for that. And Janae, I want to talk about your situation. Mm-hmm. What was it that brought you to the eviction court? How did that situation arise?
Well, like Blythe mentioned, it was a notice for rent, okay. And there was an eviction attached to that, but it was a wrongful eviction. So the amounts that were owed were inaccurate. And when I called the management company to resolve it or to get more information about it, they had informed me that they had improperly allocated multiple funds to 1 month and had neglected to allocate it to the month prior to that. And so we ended up still having to honor the Zoom meeting because we were already in the process of the court proceedings. Okay. So once we did that and I connected with Blythe, that's when she asked me what I was there for, basically, because they didn't have any kind of amounts in front of them or any kind of information that told them what I owed.
Oh, so it wasn't even clear what the amount that they were asking for?
No.
In the rent?
Absolutely not. You all had no information. And then I ended up informing her about everything else that was going on, to her point about the repairs
Yeah, let's
and the
talk about
different
that.
things.
What were the facts in your case that
So
were
the
causing trouble?
primary thing was that we were not having any heat. There was no heat that we had access to. We were definitely in the month of November. At that point, it was very cold. And there was also issues with the back door to the building being unlatchable, and it was broken, and we were having issues with like kids running in and out of the building. We were having squatters issues, all of these things. It was just completely unsafe. And once Blythe found out all of that, that's when they decided to represent me.
And had you complained about those heating issues and the door latch, that lack of safety? Had you complained to the landlord?
Absolutely. I was sending email notifications. I was having phone conversations, but I was following the phone conversations up with the emails regarding the heat, regarding the door, regarding all of those things. And they just kept saying that they were going to get back to it. Then they sent out an email saying to the tenants that we are aware of the boiler issues, but then nothing happened after that. There was no resolution for it until we started going to court.
Wow. Wow. Well, let's talk about what happened in court. And I just want to pause and say, Blythe, I can't imagine many of your clients actually follow up their messages, their conversations with emails, because
Yes.
most people don't in their lives. So
Yes.
good on you, Janae.
Today is a
Thank you.
case study in how to track what you were telling your landlord. So it was fantastic, and it made everything so much easier moving forward.
Right, right. So what happened in the case?
So this was sort of a unique case in that when we met Janae at the first hearing, we were able to agree to represent her. That doesn't always happen in the Zoom hearing. We're able to, send an electronic retainer agreement and move forward. But because there was no heat and it was early November at that point, we sort of escalated and picked up this case for representation a little early.
Okay.
So we reached out to the landlord's attorney. So when you're represented, the attorneys talk to each other. It makes things a little bit easier. So reached out to the landlord's attorney to put them on official notice that she did not have heat, and continued to do that. Reached out multiple times. Initially didn't receive any response. It wasn't until January, I believe. And we had a 2-month adjournment at this point. So that
Yes.
was a fairly long adjournment for the 36th District Court. So from, I believe it was November 11th until January 14th, we were in adjournment.
And no heat.
No heat. So, and usually when I work with landlords' attorneys and there's no heat, that's a little alarm bell, because no heat is a very big deal. It can open the door to filing what are called counterclaims. That could eventually mean that your landlord has to sort of compensate you for the fact that they did not meet their obligation to provide heat. Usually it's enough pressure to get the heat resolved. In this case, it was not.
Right. Were there other issues in your unit?
There were some other issues in the unit. For instance, I did not have radiators in all of the rooms. So there was no radiator in the bathroom. There was no radiator in my main bedroom. So I was stuck basically using space heaters for supplemental heat and staying in my living room, like during the whole winter. Plus, we had no heat during any of the holiday season.
Right, I mentioned that, November 11th, and then so you had Thanksgiving, you had Christmas, no heat
New
during
Year's,
all that time.
no heat. And Blythe actually recommended that I start taking temperature checks in my apartment. So I did that same day. She also recommended for me to start holding my rent as far as an escrow account, so that once we went through the court proceedings, we could find out what the actual abatements were going to be. So I did that, and I think the lowest heat that I tracked overall was November the 15th. It was 59.9 degrees in my apartment.
Oh my goodness. Oh. So you said a couple things I want to follow up on. One was withholding your rent.
Yes.
And so, Blythe, can you talk about when it's appropriate to withhold rent?
Yeah, so when you are in the court hearing, when the process has already been started and you know that you're going to end up owing rent at the end, you do have the option to withhold your rent and wait until you know exactly how much money you owe. There are a lot of reasons why you may or may not want to do that, so you should always speak to an attorney about what's right for you. But in this instance, because we knew that we were going to be pursuing abatement, and because we knew they had not turned the heat on and they had not indicated that they were intending to turn the heat on, it was important to set that money aside and not to continue paying at this point until we knew what the resolution was going to be.
And then when a tenant withholds their rent, do they just keep it in a separate account, or does that have to go to a special place?
It's a great question, and it's something that I wish I had an excellent answer for. There are rules that say that it should go into certain special escrow accounts, but those escrow accounts sometimes require a judge's order to open. So the main thing that we say is just try to keep it uncommingled with your personal property. So try to put it in a separate account if you're able to. The main thing is don't spend it on other things. Keep it, set it aside, because you're going to need it eventually.
Got it. So keep it in a place where you can identify it. This is the money that I need for rent if I need to do that.
Yes.
And then you've mentioned abatement. So can you talk about what that means?
Yeah, so abatement means it's money that is deducted from the rent that you owe. So the rent that you owe, the judge is always going to say it's the contractual agreement that you signed, it's the amount of rent that you owe. Your landlord is going to have to prove how much that is. So they'll need to bring some kind of a ledger to demonstrate that. It'll be higher than you think because there will almost certainly be late fees, there will be attorney's fees, things on there that they may or may not be entitled to. A lawyer can help you work through whether they are. Here, because there was no heat, we were certainly always going to ask for abatement. Some issues don't quite rise to the abatement level. You know, if you have a tile that's peeling, the paint's peeling off the tile, maybe not abatement level. Here, no heat, absolutely abatement level.
100%, right. Right. So then what happened? So we went through this process. You had the adjournment until after New Year's.
Yes.
Yeah.
Yes.
Then what happened?
So it became really apparent early January that they were not going to make this repair. So at that point, we got the court involved. So we filed an answer, affirmative defenses, and what are called counterclaims. So with counterclaims, we essentially said there is a statute called a lockout statute, and when you have essential services turned off, you can file a counterclaim. That means that you essentially become the plaintiff in a separate case against your landlord. They're just both happening at the same time. So in that case, we filed all of this. At the first hearing, the landlord's attorney told me that they would be moving to strike our answer, affirmative defenses, and counterclaims as untimely. So essentially, they argued, you didn't file these fast enough. And I explained, well, that's because we were working with you to try to get the heat turned back on to not have to do this. But alas, you failed. So the first hurdle we had to overcome was that motion to strike all of those things.
Okay. And were you successful?
We were, yes.
Right. And then what happened after that? Did you have to go to trial?
We did. So the judge ordered a trial date. So this was now our third appearance in person.
Yes.
So
Yes.
Janae then had to get down to the court and be there. And you know, many times that means tenants have to take off work. They have to pay Ubers often to get to and from court. It's an expense.
Or pay to park,
Or
which is
pay
outrageous.
to park,
right?
yes,
Yeah.
absolutely. So that was the third time we were in court was for the trial date. We needed to file trial briefs. Opposing counsel failed to file a trial brief. We were prepared for the trial that morning and found out that day that opposing counsel had unexpectedly quit the day before. So someone else from that firm appeared. And generally speaking, you know, this is a firm that we see fairly regularly in the 36th. They sent someone else who asked for another adjournment, a little more time. And at that point, we really put our foot down and said, absolutely not. Her heat was also still not on. So we were dealing with this
And
for
now you're
months.
in March?
Yes.
Oh my gosh.
I feel like that was the plan all along, to like just hold out until the weather picked up and got better. You
And
know
then it
what I
wasn't
mean?
an issue anymore.
Yeah, but in the meantime, my utility bills had spiked because I was using space heaters
Sure.
and things of that nature. And so I was just really happy to have Blythe there and the rest of the team to represent me, because as you see, all of the different legal aspects behind it, I would not have known to do that myself. I would not have known that I could possibly become the plaintiff in the situation. And the end result ended up being an abatement of $4,000 off of the-
$4,000?
Yes, $4,000 off of the rent owed. And then I moved like within a 45-day.
So you had time. You didn't
Yes,
have to
I
move
did.
Yes.
10 days later. You had time to
Exactly.
move, and you had that rent abated.
Exactly. So I was
That's
very
wonderful.
grateful, and still am so very grateful and thankful to Lakeshore Legal for that.
Thanks. Well, thank you for sharing this story.
Absolutely.
I really appreciate it. I think putting it into context in someone's life, it really helps to make people understand. And Blythe, thank you for the work that you're doing. It's incredible, and it's changing people's lives every day. So thank you
you.
both for sharing your stories.
Thank you for having me.
Thank you.
Thanks. And thanks for joining us on Legally Speaking.